Hello, good morning. This is Dr. Iftikhar Ahmed Ansari, Department of Political Science, Aligarh Muslim University. Today I am going to make a presentation on unitary government. That is one of the forms of government that is presently in the world in numerous, more in number. Now, state, the concept that we study in political science, state can have but only one government. Yet, such is the extent of territory over which many modern day governments they exercise their jurisdiction, and so numerous that it is impossible any single authority to do its work from one single center. Then it is also not the problem of doing the work, actually, it must be done effectively and efficiently. That is what the benchmark is. Now, it is therefore imperative that the sum total of governmental powers should be split up and distributed among different organs and different authorities of state, and together they should all constitute one harmonious scheme for the administration of public affairs. Now, there are two methods of dividing governmental powers. One is territorial and other is functional. Now, the territorial division of powers, they seek to divide the territory of a state into a number of districts and its divisions, subdivisions, and each of which is charged with the performance of certain governmental functions within its boundaries and is provided with the machinery of governance for that purpose. Now, the result of such territorial divisions and subdivision is the existence of national government and a series of local authorities. The functional method is that where the distribution among peculiar and particular organs of authorities is made on the basis of and in accordance with the character of the functions to be performed. Now, these two are not alternate methods. Both are used in organizations of all modern organizations and all modern governments, but differently. This leads to different character of the resulting governmental systems. Now, when we talk about division of state or division of territory on the territorial basis itself, we see the desirability of distribution of governmental powers among the territorial units results not only from the extent of the territory of modern states, but also from the fact that many functions of government affect exclusively or primarily the interest of particular localities rather than country as a whole. Now, it does not, however, mean that one single center authority cannot perform these functions. But if it does, the burden of work and responsibility would be too heavy for effective and efficient administration. Now, it would also result in intolerable expense and delay. Moreover, it is politic to entrust the small communities with the affairs that concern them alone because of the presumption that the people belonging to a particular locality can best know and appreciate their needs and understand their problems. So, besides, it gives a large number of persons an interest and share in political affairs. Now, we cannot realize the full benefit of democratic government without making such arrangements on a territorial basis in which the interest of the peripheries or those territories which are in the far corners of the state away from center are also taken care of. Now, this system of territorial subdivision is essentially similar in all modern states. First, for certain purposes which are vital to the life of the nation, the entire country is treated as one political unit, and the organization managing all such affairs is called the central or national government. Next, the country is divided into a relatively small number of important divisions, variously designed as constituent states, provinces, and cantons, etc., with a complete governmental organization of their own. Now, these grand divisions are in their turn further subdivided into smaller areas known as districts, countries, townships, communes, etc., each also have its own political organization. Now, further subdivisions, if there are any, are usually of a purely administrative character. In addition, all states recognize that urban and rural areas present different problems of government and consequently grant to them distinct political organizations for the performance of the governmental duties, especially affecting their peculiar interest. But the real problem is that of determining how the sum total of governmental powers shall be distributed territorially. If you analyze this problem, it will be found that uh, it is, it is in overall four distinct questions. Now, the first question is what authority shall decide the distribution of power between the center and the states? Secondly, what shall be the geographical system of division into different political units? Third, what shall be the power of government of each territorial unit? And fourth is what shall be the type of governmental organizations in each territorial unit? Now, for a student of political science, the first of these four questions, that is, what authority has the legal right to determine the distribution of governmental power among the different territorial unit, is much the most important, for its decision determines the character of the resulting government system. Now, two types of governments are generally formed on this basis. One is the unitary, other is the federal. Now, two systems are found in modern states with two types of resulting governments, that is unitary and federal. Now, today we are talking about the unitary government. Now, unitary government is a single integrated system of government for the exercise of all powers. The legal sovereign confers all the powers of government in the first instance upon a single central government. The central government may exercise all these powers by itself or create political subdivisions and delegate to them such powers as it may deem wise to delegate. The central government is competent to change their boundaries as well as the powers at its own pleasure by ordinary legislative enactments. So, a unitary state is a sovereign state governed as a single entity in which the central government is the supreme authority, and the central government may create or abolish administrative divisions, that is, sub-national units. Now, such units exercise only the power that the central government chooses to delegate. Although political power may be delegated through devolution to regional or local governments or by statute, the central government may override the decision of devolved governments, curtail their powers, or expand their powers. So, unitary state in its modern concept originated in France in the aftermath of 100 Years' War. The national feeling that emerged from the war unified France. So, 100 Years' War accelerated the process of transforming France from a feudal monarchy to a unitary state. So, France then later spread unitary state by conquests through Europe during the first and after the Napoleonic Wars and to the world through the vast French colonial empires. Now, if we talk about the features that we have about this unitary form of government, we find that number of countries like Britain, France, Italy, Belgium, Japan, Afghanistan, Iran, and many other countries, all in all, more than 150 countries presently in the world out of 193 have this unitary form of governments. Now, there is one integrated system of government, and the supreme power belongs to the central government. For administrative convenience and other considerations, the country may be divided into political divisions of different categories, but all authority flows from the central government. Now, these subdivisions have no original existence of their own. They are the creation of central government and may be altered at its will. The power exercised by them is only a delegated and subordinate authority which can be increased, diminished, or withdrawn at the discretion of central government. The subdivisions are therefore the agents of central government, and whatever authority or governmental competence may have been conceded to them exist by sufferance rather than by constitutional guarantee. The real point to know is the authority by which such areas are established, and their powers and governmental organizations determined are basically the one which is devolved from or given by the center. Britain allows maximum autonomy to all her local areas, but they are the creatures of parliament, and all such powers are determined and derived from the acts of parliament and can be enlarged or restricted at the will of the government at London. Now, what Whitehall also exercises Whitehall also exercises considerable administrative control over all such areas, as Ogg sums up, saying, all told, however, central control is both wide and deep. Not only so, but it is steadily penetrating to new spheres and new levels. Now, another feature is that of the centralization tendency in the unitary form. Now, in this case, we'll take the example of France. Now, France is divided into administrative units called departments, which are divided into cantons and arrondissements and communes, now, each having its organs for local administration. But general opinion is that it's almost misleading to talk about local government in France, because centralization is the essence of French local government. Now, centralization raised to a superlative degree, all authority converges inward and upward. So, the local organs are merely agents of central government. From the communes to the Ministry of Interior, the administration is linked up in one chain. The Minister of Interior just presses a button. The prefects, subprefects, and mayors do the rest. All wires run to Paris, as it is called. So, Ogg and Zinc gave a matter of fact summing up of the nature of local government in France. They said that not only are there no constitutionally separate sphere of governmental authority, there is really one government functioning equally through ministers and parliament at Paris and prefects and councils throughout the country at large. Local area save only governing organs, local bodies only such powers as are given to them by national law. All of the threads are gathered ultimately in the hands of the central government at Paris. More than this, the entire mechanism of governments, entire mechanisms of departments, the communes head up at a single ministry at the capital, that is the interior. Now, talking more about unitary character, we find one of the countries, that is our own Government of India, it was the Unitary Charter under the Act of 1919. Just to understand the Government of India Act 1919, we come to know the unitary character, how it is made and how it is made to function. Now, although the provinces were given a partial responsible government called diarchy, and the central and provincial subjects were demarcated normally following the provinces to legislate on provincial subjects, yet the Government of India at that time, under Governor General, was supreme in all affairs of provincial governments, executive and legislative. The Act of 1919 had vested the superintendent's direction and control of the civil and military government of India in the Governor General in Council, who was required to give due obedience to all such orders as he might receive from the Secretary of State for India. The Governor General had wide powers of assenting to, vetoing, or of reversing for the significance of His Majesty of King Emperor, and of returning for further consideration bills passed by the central legislature. He could exercise similar powers in relation to bills passed by the provincial legislatures. So the Indian legislature was competent to make laws for all persons and all things within British India, except that the previous sanction of the Governor General was necessary for the introduction of any measure regulating any provincial subjects as classified according to the Government of India Act 1919. Now, similarly, the central legislature had the power to repeal or amend any law in force in any part of British India, except that the previous sanction of the Governor General was necessary for introducing a bill, repealing or amending any act of a provincial legislature. Now, another feature of unitary system of government is single constitution. Now, a constitution is a set of fundamental principles or established precedents that form the legal basis of a government or organization. Now, it determines how that entity is to be governed and can be written down in a single document or set of legal documents known as a written constitution. However, some constitutions are uncodified, meaning that the fundamental rules are not written in a single document but are instead found in customs, usage, precedent, and various statutes and legal instruments. In an uncodified constitution, the understanding of the constitution is obtained through reading commentaries by the judiciary, government committees, or legal experts. This type of constitution offers flexibility and adaptability, but controversies may arise due to different interpretation of its provisions. Now, there are no separate constitution for the state. In a true federation, there are separate constitutions for the union and the state. Another unitary feature is the single constitution that governs both the center and the states. Now, this means that both the center and the states, they operate within the same framework, and there is no provision at all of having a different constitution, although similar in fashion, but some different devolution of powers written in the constitution given to the states in a unitary form of government. Now, if we talk of and look at the central's control over the states to see the nature of unitary form of government, we find that the states have to respect the laws made by the central government and cannot make any law on a matter on which there is already a central law. So power is concentrated in a single central authority, and in this system, the central government has the ultimate authority and can create or abolish administrative divisions as it sees fit. So the central government can also delegate certain powers to regional or local governments, but it has the power to override their decisions or limit their powers. Now, this is different from a federal government where power is shared between the central and the state governments or regional or local governments. Now, moving on to another feature of unitary government, we find that upper house in that country where the union government is located, that upper house does not represent the state's equality. Now, in a federal setup, generally, states which come to form a union or come to form a federation, they form it on the basis of equality. But that equality is missing, the concept is missing in the unitary form of government. So, in true federation, the upper house of the legislature has equal representation from the constituting units or states. In United States, however, the principle of equal representation of states in the upper house is fully recognized, as it is an ultimate example of federalism in the world, where the upper house has the two members from each state, and that comes to the 100 members in Senate, that is the upper house of Congress. Now, as a result, the American Senate has 100 members with 2 representatives from each state. Now, this principle is thought to protect the smaller states. Now, this concept is not there in a unitary form. They might be having the upper house, but that upper house is more formed on the basis of and in proportion to the population, not on the basis of equality. So the smaller states will have lesser number of members in the upper house, and the larger state with huge population will have more members in the upper house. Then there is existence of the existence of state depends on the center in unitary form of the government. That is yet another important feature. So in a unitary state, the central government holds supreme authority and has the power to create or abolish administrative divisions. Now these divisions, also known as the subnational units, only have the power that the central government chooses to delegate to them. While some powers may be devolved to regional or local governments, the central government can override their decisions, limit their power, or even expand their powers. So, unitary states differ from federations where power is shared between the central and the regional governments through a written constitution. In federations, subnational units have a right to existence and powers that cannot be unilaterally changed by the central government. However, in unitary states, the central government has the authority to make changes to the territorial integrity of the state without the consent of subnational units. Now, it is important to note that decentralization can exist within a unitary state, but it does not guarantee the same level of autonomy as in federations. Now, devolution within a unitary state can be symmetrical, with all subnational units having the same power and status, or asymmetric, with a varying degree of powers and status among subnational units. Now, in some unitary states, the subnational regions do not have the ability to make their own laws and are subject to the decisions of the central government. So, the boundary of a state can be changed by creating new states out of the existing states. So, the states in India, for example, do not have territorial integrity and can be changed by the central government. Now, yet another feature of unitary government is single citizenship. Now, the single citizenship refers to the concept that a person can only be a citizen of one country and not multiple countries, or one center, not the states within that center. So, in India, the constitution provides for single citizenship, meaning that all citizens of the country belong to Indian Union and not to any specific state. Now, this promotes a sense of unity and brotherhood among the citizens of the country. Having single citizenship has served many and several advantages. It increases the feeling of nationality, it encourages patriotism as it forges unity among the regional and cultural differences. It also ensures that all citizens enjoy the same political and civil rights regardless of the state they reside in. Now, this means that there is no discrimination between citizens based on the principle of residence. Single citizenship also allows the fundamental rights such as the freedom of movement and residence in any part of the nation. Now, in contrast, some countries have dual citizenship where a person is a citizen of both the country and the state in which they reside. Now, this can lead to certain drawbacks such as one state discriminating in favor of its own citizen in matters like the right to vote or hold public office or practice profession. However, in India, we find the concept of single citizenship, which ensures that all citizens have equal rights and obligations throughout the country. So, a country which is unitary in nature, it promotes this single concept of citizenship. Now, in true federal state, citizens are given dual citizenship, and in India, however, the citizens enjoy single citizenship, that is Indian citizenship or the citizenship of the country as a whole. Now, further, another very good feature of the unitary form of government is unified judiciary. Now, it generally means that the courts are organized and structured in a way that moves away from locally controlled courts to a statewide system. Now, this can include having two trial courts for different types of cases, placing rule-making authority in the hands of Judicial Council and giving administrative authority to the Chief Justice and the Judicial Council. However, different states have different interpretations of what a unified court system means, so there is no one-size-fits-all definition of unified judiciary. On the other hand, when we talk about an integrated judiciary, it means that the decision made by higher courts are binding on lower courts. So in India, for example, the judicial system is a single unified system where all courts from the Supreme Court to the lowest district courts are part of a single hierarchy. This ensures a uniform interpretation of the law throughout the country and provides a mechanism for appeals to higher courts. Now, it also helps correct errors and ensures fairness in legal system. The idea of a unified and integrated judiciary is not unique to the United States or India. Many countries have a similar system in place to ensure a fair and accessible justice system. The legal history and evolution of judicial system plays a crucial role in its success. Now, it is important to have a well-defined system of law which is consistently applied and hierarchy of courts that follow a primary procedure. Now, this ensures that justice is served and impartiality is maintained. So, India has a unified and integrated judicial system. The Supreme Court is the highest court of justice in the country, and all of the subordinate courts are under it. So, decisions of higher courts are binding on lower courts. So, in India, we do have such features which have a central tendency and also federal features, and that is why we say that India, we have a federal government which is leaning towards a central form of or unitary form of government. Now, with that, I come to my presentation for today, and rest of the lecture on the same topic will continue in my next video. Thanks for today. Thank you.